Welcome everybody in the room. Thank you very much for coming out for our December lunch on hot tax topics, three particular hot tax topics in particular. And thanks also to everybody on the phone. We have over 250 people registered for the webinar, so we're looking forward to getting questions from you all. I'm Cindy Lewin. I'm chair of the Nonprofit Organizations Practice Group here at Venable. And our group is a little unusual in that it's organized around being full service for nonprofit clients instead of being organized around employment, trademark, or a particular legal, although I would argue that there is a body of law called nonprofit law. But in addition, I see nods, thank you. But in addition to that, we also have experts in employment, in trademark, and all over the firm who work with our nonprofit clients. We're very happy to have two of our guests today from the tax department. I'm thrilled they're here. I'll introduce them. Walter, to my immediate left, is a partner in our Baltimore office, specializing in tax-exempt bonds, project finance, but also in state and local taxation, as you'll see. And Liz Steve, further down, also in our Baltimore office, does a lot of mergers and acquisitions and also a lot of tax of all kinds. She clerked for the tax court, which I love. There's a tax court judge on my tennis team. It's given me a whole new view of tax court judges. But in any case, and also has an LLM in tax from Georgetown. So I'm delighted to have these experts here. And with that, I will turn it over. Walter, I think you're going to start.
Yes. Am I coming through? Yeah. Okay.
Oh, sorry. I'm going to interrupt you and just say one more thing is I'm not being rude up here checking my email. We will take questions as we go. And the questions from the webinar will come to me on my phone. So that's why I'm looking at my phone. It's not because they're not gripping.
So people should just wave their hand at you if they got a question.
Yes, and people in the room, just raise your hand.
Well, we got mics somewhere.
And there's a mic there and a mic over on the other side of the room as well. Okay, sorry, Walter.
No,
to you.
So I'm looking at an article here from one of our local newspapers for the Sunday after Thanksgiving, the Sunday before Cyber Monday, and the headline is Cyber Monday shoppers to see something new, taxes. And so that's the main core of our theme that we'll lead up to today in the sales tax piece of our discussion. I'll spend most of my time talking about sales tax and building up through a very simple discussion of sales tax to the Wayfair case that came down back in June. Spend a few minutes after that on property tax in a similar vein, and then Liz will jump in on a whole new topic of perhaps interest, opportunity zone funds. So in the world of, nonprofits, we begin with the very simple split of nonprofits buying things versus nonprofits selling things. And I'll go down both those tangents because they lead in different directions. Sometimes they come back together. But we'll head down first the buying topic of when nonprofits want to buy things, the sales tax world begins with the presumption that everybody pays sales tax on everything that is, by a particular state, subjected to tax. And historically, things that are subject to sales tax are tangible personal property, stuff you can touch, stuff you go to the store and buy. Increasingly in recent years, states have, as they've looked to, and this will be a theme through our discussion, expand their tax base, expanded beyond tangible personal property to downloadable type products or services, or two of the big areas now being expanded to covered by sales tax. Here's a quick overview on the states. And another theme you'll hear me constantly say is, well, two themes. One is we've got 45 states in the district that have sales tax, and while there are common themes among the states, there are many differences as there are common themes, so that if you ask me a question about any one state, I probably don't know the answer, but I can give you the theme on what this topic is. The other theme is the laws keep changing, and so this is a chart. Tax Foundation does some great charts, and this is one of their charts. If you see what the chart actually shows, it's got the District of Columbia at 5 3/4%, but within the past month or so, district changed that up to 6%. So states, get incentives to lower taxes in some good times, and then they get short and they go and raise the taxes again. And so as news tax rates are constantly moving around, And one of the real frustrations among many with sales tax is the fact that, well, in D.C. and Maryland, we've got it fairly simple because we've got a single rate. But in most states, you're going to find when you go into a city or a county, you're going to get add-on rates, which means across a given state like California, there may be hundreds of different rates when you layer on county and city taxes, which is keeping track of a rate that will apply to a given sale can be a challenge. So the big picture theme of, okay, you're a nonprofit organization and you're buying goods or services, and you begin with the very simple transaction where your organization is here in D.C. and I'm going to sell you something, and so we've got a D.C. sale, and D.C. is going to assert the right to tax that sale occurring here in D.C. And as an exempt organization, you would prefer not to pay the add-on tax. So the usual starting point in this whole process of how do you get exemption envisions a brand new organization or an organization for the first time coming into a state and registering to do business because the organization has started of its own accord to be doing business in a state to a significant enough level that it needs to go and register to do business. And that's really not a tax concept. That's really more of a corporate law concept of registering with the state in case you ever want to use the courts in the state. But when you head down that process, and that's not really the focus of what many of you would encounter with another state, but if you have a new organization or you are going in a new state, that process will usually veer off into, well, when you register, you also are signing up for our taxes to let us, our taxing authorities, know you are here. And then the next variation on that is it's also time for apply to exemptions. When you're telling the tax authority, gee, we're doing business here, we're here. As an exempt organization, you're going to be trying to tell them that you're exempt from as many taxes as you can tell them you're exempt from. And that's generally include, income tax, sales and use tax, and property tax are probably the big three that exempt organizations are somewhere along the spectrum going to try to qualify for in a given state. Let me see. So in D.C. is just a simple example of this, where in D.C. there's a single form you file to request exemption for both their income franchise tax, sales and use tax, and personal property tax. And again, a very great variation across the states is, well, who's going to qualify? And if you've got any familiar with federal law, the golden standard is 501c3 organizations. They're sort of the highest level standalone charitable, educational, religious, scientific organizations. And so most states are going to give them respect for their exemption. But once you move away from 501c3 status, it's much more ad hoc whether a given state is going to give you the respect of getting exemption for these various taxes. In D.C., there's a distinction that's going to go with, well, let me back up to federal law. Federal law is just a totally different universe. It's an income tax, and we'll come back to this a time or two, that income tax is different than sales tax. Your probably starting point as an exempt organization getting exempt status will have been with the IRS qualifying as a 501c something, and then you're going to be trying to take that to the state and get a state benefit out of it. And when you look at the list for D.C., you've got income and franchise tax. So most states are going to take the fact that you are exempt from federal income tax and simply carry it over. And so if you're pretty much in any 501c category exempt from federal income tax, that's typically going to carry over to an exemption from the state income tax side of things. But as I just headed down, not necessarily from other taxes, and sales tax in particular. In D.C., that's where things are. D.C. is going to generally give you income and franchise tax exemption if you're exempt federally, but is much tighter on personal property and sales and use tax. It's got a quirky phrase of a semi-public institution is the magic word in D.C. law for exemptions. That is their broad category. But then, as Cindy was commenting to me earlier today, when you look at D.C. law, what did you tell me? That
you practically need a statute to, you need your own personal statute. The statute in D.C. is full of organizations that have gotten their own exemption.
Yeah. You'll see this broad category I mentioned, which is generally going to sweep in your 501c3 organizations, charitable, religious, educational type organizations. But then there is the laundry list of everybody else who's been able to get somebody in the state, in the D.C. government to help them get their own exemption.
This is the lobbying capital of the world, after all.
And to be clear, other states are not immune from lobbyists. You will see the same thing going on in other states. There are favorite organizations that you'll see run as a theme. Parent-teacher organizations are one. Volunteer fire companies are another. That in most states you'll see somehow have their own special rules. And we'll get to that sort of on the other side of this discussion in just a minute about selling things. But that's kind of the general concept of take your sales and use tax, your federal income tax exemption and make what you can out of it at the state level. Again, with each state having its own process and requirements. And at the end of that process, being successful, you will typically get a number and a certificate. And that's what's actually of use when you need to actually make use of it, is whether you're ordering online or just going into Home Depot to buy some, or CVS to buy office supplies. To get the exemption, they're going to want to see your number and or your certificate as the basis on which they can be comfortable in not collecting sales tax on your purchase. And here we move a little into the Wayfair world, when the Wayfair world is really the world of, okay, your organization is here in D.C., I'm here in D.C., we have a sales transaction here in D.C.
Walter, before you move to the Wayfair world, we do have a question from the webinar about sales tax exemptions. The question is, if you're having an auction at a fundraiser, are you required, recognizing that state laws differ and that there are themes, would you be required to collect sales tax when you're essentially selling things through a charity auction?
The starting answer in my mind is always in sales tax, yes. Assume, and this is covered in a very brief overview and later in the discussion here. But in brief answer, you've got to assume you're subject to, well, I'm sorry, they're asking about selling things, right?
Yeah, so I guess we're getting into selling.
We will get to that, yeah.
Yes.
Let's hold that, because that is, we're headed down that whole topic in just a minute. I've headed off on the theme of where Wayfair eventually gets us here, which is, okay, I'm selling your organization something in D.C. D.C. is clearly going to assert the right to tax that. The sale has occurred in D.C. Okay, but move me a few miles away. Put me in Virginia or Maryland, and you have ordered something from me to use here in D.C. In that situation, I'm selling you in D.C., and generally if you provide me, well, we're headed in many different directions here. One is whether I even have the obligation to collect D.C. tax, and let's say I don't. In that case, this is the world we have all wonderfully lived in for many years, which is you go online, you order something, and wonderfully there's no sales tax because I, as your seller in Maryland, let's say, have no obligation to the District of Columbia to collect that tax. And I'm going to go over this point several times because it's probably the single kind of ground piece of where Wayfair comes into being is if your vendor is in a different state, you've got two different state laws to try to deal with, the state where the seller is and the state where you're located, the buyer. And the thing to keep in mind is that your certificate from D.C. is only good with respect to D.C. sales tax. So if you've got a trade show in Philadelphia and you're needing to go down the street in Philadelphia and buy some supplies for your trade show there, well, the local vendor in Philadelphia has no reason to recognize your D.C. sales tax exemption. It's only good within the borders of D.C. There's the fundamental caveat that always gets imposed on most anything in the exempt organization world is all these rules only apply to the extent the things you are doing or buying are within the scope of your exempt purposes. For many exempt organizations, they have reason to at times do activities outside the scope of their purposes, and sales tax laws are always written to carve out those things. So that the exemption won't extend to something unless it's consistent with your federal income tax exemption for unrelated trade or business being carved out. So now I want to go down, again, this prong, which is really where we go with Wayfair eventually. And I'm still on the sort of buying side, where you're buying something, but I'm beginning to move over to the way you're selling something. So just take your own personal situation, because it's a very good example of all of us engaging in significant tax avoidance. Historically, I mean, I've heard of these European countries, particularly in Southern Europe, where you'll hear them talk about what the low rate of tax compliance is, or something like property taxes. Right. And I often think, how does a country get by with that, where people just don't pay the taxes they owe? Well, use tax is the U.S. corollary of that, in that states have long had the concern that you could go over to Delaware, where there's no sales tax, buy all sorts of stuff, bring it back to Maryland, D.C., Virginia, and no taxes paid. Or you could, in more modern age, go online and order over the internet, and same result. There has always throughout history been, in parallel to the sales tax, a use tax. So the sales tax is conceptually based on the sales transaction occurring and being taxed on that you bought something. But because of the situations I just described, there has always been a parallel use tax, which is that any of us who have bought property and are, quote, using it, end quote, in a jurisdiction are obligated to pay use tax based on our use of it if sales tax has not otherwise been paid on it. I don't want to point at anybody in the audience, but I suspect I could point at most anybody, and you probably have not been complying with use tax laws. There's some states, I don't know if Virginia still does it. Virginia used to have on the bottom of their income tax return a place for you to voluntarily self-assess and report your sales tax, your use tax. As is, I think, clear to all of us, the compliance efforts by state and locals on the use tax side have been very negligible. The focus has always been on collecting from the seller just because of the sheer volume. There are 100 sellers and there are millions of buyers. So it's always been trying to get the sellers to do the collection process. Let's see where we're going here.
Oh, we have a question in the audience. Oh, can you come up to the mic, or we can repeat the question? So the question is, if you're buying educational materials, you're in DC, you buy educational materials off a company's website, what is the sales or use tax consequence? Or your members are buying your publications. You're in DC and your members are downloading and buying stuff all over the country. Right. So you're selling you, the exempt organization, are selling something. And the question is, as a seller, what are your sales tax collection responsibilities? And I see from this slide that says sales by nonprofit organizations. I think we're about to
That's a
launch
good lead into
that.
the topic, yes.
Perfect. That is the hypothetical we will consider, because that's exactly, I think, what many, many nonprofits are doing. They're selling things to their members all over the country, but they're in one place. And everybody thinks, oh, I have a sales tax exemption. As Walter was explaining, that's really meant to cover things I buy. But so many people think it also covers things they sell, which is not true.
Yeah, so in general, the exemption certificate you've gotten that I just spoke about on the buying goods side of things will have no application on the selling goods side of things, so that virtually always when an exempt organization, nonprofit, is engaged in selling activity, their exempt status is not going to assist in any way in relieving them from an obligation to collect tax on that sale if they, in fact, have an obligation to collect tax, which, again, is where Wayfair takes us, is when do you have the obligation to collect tax? Again, there are going to be exceptions, but they're few and far between in situations where exempt organizations may be exempted, transactions are exempted from sales tax, and you're going to see some things, quirky things in statutes where maybe the local Girl Scouts get exempted on their cookie sales, or the local PTA gets exempted from its fundraiser from having to collect sales tax. And you sort of end up just with some odd situations which are out there where tax sort of doesn't apply because the statute has, some lobbying group has gotten a unique exemption put in there. But big theme, nonprofits are obligated to collect sales tax when they are obligated to collect sales tax. So go back to my simple example. If you're based in D.C., your organization is based in D.C., selling goods and services that are taxable goods and services under D.C. law. And I walk in to say you're a museum thrift shop, or I'm sorry, a museum gift shop, and buy something there, some souvenir. Well, in the first instance, there's no reason sales tax shouldn't apply to that sale. And as the exempt organization, despite that status, you're going to be obligated to collect on behalf of the D.C. government that tax. Where it quickly becomes complicated is when you move me across the state line, and this is really where your question goes, is as soon as I'm outside of the jurisdiction, and here's where we begin on the Wayfair topic, is if and when does your organization have enough contact with another jurisdiction that other jurisdiction can obligate your organization to collect sales tax on behalf of that other state? Make sure I'm not losing track of us.
Yep. Right. So this is going to go directly to your question, because if you are just an association located in D.C. with no other offices and no other employees, so one would argue you did not before have those contacts, right?
Depends on what your contacts are, right?
Exactly. I'm just the straight man here.
So prior law, up till this year, well, they back up a step. There's always been the question of, well, who sets these laws? Well, what sets the standard, or what the connections are adequate? And it goes into the U.S. Constitution as interpreted by our courts as to what our standards are in terms of when your organization will be deemed to have enough connections with another state to obligate you to collect sales tax. And historically, that standard has been one for many, many years, 20-some years now, of physical presence. So if you're based here in D.C., the question in the past has been, do you have physical presence in Maryland, where I happen to be ordering something from you, be it a downloadable good and service or a book that you're going to deliver to me in Maryland? And we're not focused on D.C. sales tax here. The quirk in the way the states have administered things, it's always focused on where the buyer is. So the question is, Maryland sales tax, do you have to collect it? And historically, that's been a question of, do you have an office in Maryland? Do you have a warehouse out of which you stock your stuff in Maryland? Do you have employees in Maryland? Do you have agents regularly in Maryland? And that's been the standard, which was fairly clear in most of the time, but a lot of the time did get gray. And I've got to say, in more recent times, it's gotten a lot grayer because of what you all do. More and more frequently, you all have been hiring people that you call telecommuters. And this will be somebody who's not going to be working out of your main office, but is going to be working someplace else. And as our economy has moved toward the ability to work remotely, this has been a really difficult topic to advise on, of when you hire somebody who maybe needs to come into your office once a year, maybe once a week, but for the most part, they don't need to work in D.C. They're fine working wherever their place of residence is. And that ends up being a connection where your organization, particularly if they're a W-2 employee, a little grayer if they're an independent contractor status. But if they're home, they've got an office, well, is their home office sort of your office in that jurisdiction because it's your staff person working there? That whole movement has led to, among other things that have happened over time, but has been one of the challenging areas, when do you have connection in a state? And that goes for all types of businesses, whether it's income tax, property tax, and sales tax. Do you have your own business essentially having an office in another jurisdiction? But that was the old standard. And I say old standard, it still lingers out there. That's still a question you have to ask, is do you have physical presence? That standard hasn't gone away. But what happened with Wayfair was that the economy moved and there was an awful lot of stuff being sold online. States realized they were missing out on it because of this physical presence standard, which was the law. And states began to say, well, we're going to ignore the law. We're going to come up with our own standard. And we know where this is going to go. They knew where it was going to go. They knew it was going to go into litigation, but that's what they wanted to have happen. And the state that was the one that happened to be the test case came out of South Dakota, where what they chose to do was something that really comes out of the income tax world, where there's longer been a lesser level of activity required for the state to subject a otherwise out-of-state company to its taxing jurisdiction, a concept that has, among other names, economic nexus as its name, nexus being the concept of connection, physical presence being the old nexus standard for sales tax, economic nexus being the new Wayfair standard. And what South Dakota and a few states did was say, we're going to reset the standard from physical presence to the volume of your economic activity in our state. And South Dakota's standard was, well, how many sales transactions are you incurring in our state? And they picked the number 200. And they said, alternatively, well, maybe you're only doing a few sales, but if the dollar volume's big enough, their number 100,000, then we're going to deem you to have had enough connection if that number is run over in any given calendar year that you should be collecting our sales tax when somebody elsewhere sells to customers in our state. So that would mean that back when South Dakota enacted that law, if you were having members located in South Dakota downloading your product, buying your books, South Dakota would have said to you, well, if you've got more than 200 transactions in our state in any year, we're expecting you from your D.C. office to begin collecting our South Dakota sales tax on your sales into South Dakota. Well, the big internet vendors didn't like that. They've been fighting, many years, this movement. The case went to the U.S. Supreme Court, which decided to change its own standard and acknowledge that South Dakota could do what it wants to do. And this shows you how quickly this has happened, and that if you look at the blue on this state, it is the states that as of June were now asserting this concept of economic nexus. And this is a concept that really didn't have any approval prior to June, and as of a few years ago hardly existed. So the blue states several years back, there would have been no blue. There was no concept of economic nexus. The blue states are now the states that are saying even if you don't have physical presence, if you cross over these economic thresholds of number of transactions or volume of dollar transactions, we expect you to be collecting our sales tax. And the Supreme Court has said that's right, we can do that. What's interesting is how quickly this changes, because if you look at Maryland and D.C., they're both still in the sort of yellow-orange color, which did not assert. Well, since June, Maryland, by regulation, has put in place economic nexus. And Maryland right now, I don't know if it's passed. It's probably going to pass any day during the month of December. If it hasn't, has put in its economic nexus bill, which pretty much parallels the South Dakota standards of 100,000 sales, 200 sales by quantity. And so you've got, just on that chart, two states that weren't there a few months ago now popping on, turning blue, and having economic nexus standards.
A question in the audience, then we have a couple from we have 1 million from the webinar as well. Jennifer, can you pop up? The mic's right behind you. It's not actually on, but at least I appreciate your going there. We'll just repeat the question.
So
there it is. There it is.
Thank you. Definition of sales, would that be a thing, or could it be a conference? Like if over 200 people come to a conference, in D.C.? Are those 200 sales? Do we know?
Well, I was thinking about writing an article about that topic, truthfully, because Maryland just enacted its provision. It's got just essentially the words you see here, 200 sales. And that is it's one of the questions that I don't know of many states that go to that question of answering it yet. There are some, maybe there's one or two that have, but I've seen more academic literature on the topic than I have actual states answering the question as of yet, as to, if you order a book and download in the same invoice, is that 2 sale transactions or is that 1 sale transaction? And so I don't really know of an answer on that. And so I guess the answer at this point is you could take a liberal position in your own favor at this point, but absent looking at a particular state and seeing whether that state had chosen to give guidance on that topic. In most states, Maryland being the one I just happened to look at, there is no guidance on that topic. It is very much an open issue. And as I was thinking about writing an article about how Maryland should provide more guidance so that we have clarity of how you count transactions and just how this dollar volume will work.
Is it clear that conference registrations are subject to sales tax? I mean, are they sometimes services or?
No, I've done a bit of work on conferences over the years, and typically the registration will not be. And if you've got a nice tag thing labeled registration, it's generally not going to raise the question. But when you get into the nitty-gritty of conferences, it gets much more challenging.
You're getting meals, you're getting books,
yes,
or conference materials. So if you broke down your thing and it said conference attendance, and then it said, if you want a hard copy of the conference materials, it's another $485, that would create a sales tax obligation there because you're now getting a tangible good or service?
Yes. It heads down that path. And often when I encounter that, it's not the simple or the base case where it's your D.C. organization holding a conference in D.C. It's your D.C. organization holding the conference in, name your big conference center, Atlanta, Philadelphia, Las Vegas, where you're not dealing with D.C. law, you're dealing with that jurisdiction's laws, and it does get pretty esoteric what you're getting into because you get into questions of, well, we're offering a tour of the museum down the street type thing being an add-on, and then you get the question of whether, should you be collecting the state's taxes that apply to that when it's broken out as an add-on item.
Well, that's interesting. We had a webinar question about the conference registrations too, so clearly that's a hot topic. And also about when you allow people to download all over the country, going back to the question that was asked in the back, is the download a sale? And I assume if you're not charging for it, it's not subject to sales. And if it's subject to use, nobody's even trying to enforce that. But is that correct? That it's just the mere fact that you're letting people download does not create a sale, but once you charge for it, you're getting some concrete thing.
Yes. Again, historically, the sales tax world has been one that's focused on tangible things, books, hard things that are sold. But they have moved toward, as more and more sales has gone toward the streaming and downloading topic, more and more states are trying to tax downloadable content. And that is, again, going to be the end user state. Take South Dakota. If you have something you've sold and a price is charged for the download to somebody in South Dakota, and a downloadable product under South Dakota law is taxable, and you from D.C. have sufficient contacts with South Dakota that cross this nexus standard, then you would be obligated to collect South Dakota sales tax on the sales price for your product that's been downloaded by your member in South Dakota.
So if you have this is another question for the webinar. It's a sort of a collection of questions. If you have a sales tax exemption certificate in D.C. and you're buying, who else has to accept that? Does anybody else have to accept that? And if they don't, can you get a sales tax exemption for things you're buying or you may be the seller, as in the one of the hypotheticals, both the buyer and the seller are nonprofits with various exemptions, but everything's happening in another state. So if you're a D.C. organization having a big conference in Chicago, you can actually get a sales tax exemption in Chicago. But you have to apply and deal with all of that. So how local is it, and how much can you do with in other states as an exempt organization based in one state without connections? Sorry, that was many, many questions. They're all from the phone.
Yep.
They're all from the webinar.
Let me go back to the basic principle is when you obtain your exemption, it applies only to when you buy goods, and it only applies with respect to the jurisdiction from which you've gotten the exemption. So that if you're based in D.C. and you've gone to D.C. and gotten your exemption certificate and number from D.C., that is only going to shield you from buying goods in D.C. When you go on the internet and try to buy something from a remote vendor, what they are collecting, and this goes back to the confusing sales use tax topic, what they are obligated to collect, if they are obligated to collect, is going to be D.C. tax. So in that context, your exemption can apply, but you're going to need to be providing them your D.C. exemption number and have them comfortable with respecting your D.C. exemption number, which could be a challenge. You may have a Vermont-based vendor selling you something, and they may not be real happy with taking your D.C. exemption number because it may not mean much to them. And you can get forced down a path where you have to pay the tax and then go ask D.C. for a refund of it if your remote vendor won't accept your D.C. sales tax number. As was alluded to in your question, you can go off to all 45 states and the District of Columbia and for mega bucks, try to process exemption applications for when you buy things in all those states, but hardly anybody wants to do that.
Right. But you would do it if you had a big conference.
If you did,
for example,
or if you had,
it would be worth it.
If you had
location.
affiliates or something scattered in multiple states.
Right. So here's another question. Speaking of doing business in other states, this is another webinar question. And you were talking about having a physical presence or now having an economic nexus. If you register to do business in a particular state for whatever reason you may have, does that automatically create sales tax nexus under either the old or the new law or regime, I should say?
No. There's always a challenging question of whether when you register to do business, it crosses over and subjects you to a state's tax. And there's no necessary harmony between the two in that having registered to do business does not necessarily mean you are engaging in enough activities to subject you to either income or sales tax. But as a practical matter, once you've registered to do business, it is certainly indicating to the income tax authorities in that state that you are in their state doing business, and it will be unusual if once you've registered to do business, the income tax authorities in the state don't come and ask you why you are not filing an income tax return and then requiring you down the path of justifying your exempt status or otherwise justifying why you're not filing an income tax return. It won't necessarily take you into the sales tax topic as much because there's no necessarily correlation to whether you're selling stuff. It's sort of a different universe. But did I cover that one there?
Yeah, I think so. Judith. Yeah. You can go to the mic even though the mic's not working, but I appreciate the visuals, the optics. Yes.
Am I good? Okay.
Yes, you're good.
So I'm curious, in terms of, for purposes of the economic nexus, if I'm the buyer and I live in Virginia and I get both a downloadable version as well as a physical version of a book, and I choose to download it in Virginia, but then I ask for the physical book to be mailed to DC, where's the sales actually happened?
Okay. Did Cindy ask you to go ask that question? We go back to some basic principles of sales tax law, which is if things are bundled together, the presumption in sales tax law is if there's a taxable component to what's being sold, the whole bundle is taxable. So at first it begins in part just as a simple invoicing. If the whole thing is bundled together, it's generally going to be a taxable transaction. Now, I guess your facts were you're located in Virginia, residence-wise, but you choose to get it shipped off someplace else. And
to your office, say.
To your office, say. I guess it, again, depends on how your vendor is invoicing that. If the download is not taxable in Virginia, I think on your facts you arguably avoid tax entirely because your vendor, it depends on where your vendor is too, but if your vendor stays in Virginia and they stream it to you in Virginia and they don't have to collect because it's not taxable in Virginia and they're not obligated as a vendor to collect DC sales tax on the book, then arguably you are just left with the obligation to pay use tax, as I'm sure you would do to DC. So, does that cover you there, I think?
I guess I was asking about the nonprofit.
I'm sorry.
County, the sort of economic nexus,
Oh.
100 sales in a particular state. What do you look to in terms of where the sale occurred?
So the question is whether leaving aside the sales tax treatment, whether that would count as a sale or transaction for getting the number of transactions you need for the economic nexus to apply.
Yeah, that I think goes back to the unanswered question of just how will states count the number of transactions. I mean, my guess would be Virginia would count that as one sale if they deemed downloadable products to be a taxable transaction, and DC would count that as one sale. And embedded within your question, I'm not sure it's what you were asking, was when you're counting transactions, do you count transactions that aren't taxable transactions? And that's another open question of in counting aggregates.
So I'm just going to ask one more question and let you get, in the interest of time, let you get going, although there are many questions coming in. So that's going back to that question we got about the auction. If you're selling, now that we're on the topic of when is something that you're selling taxable, is maybe if you're having a once a year charity auction and you, the charity, are essentially selling things to bidders who are buying them. Of course, there's a whole issue about what is the sales price and how much is the donation. But is that taxable? Is there a casual sale exemption or something else that might apply?
Well, you happen to have timed that question perfectly with the slide.
Oh, look, casual sale.
Yes. So again, back to general themes, all sales are taxable unless somehow there's an exemption. So I think probably virtually every state has some variety of what gets tagged as a casual, isolated type sale transaction, which is really intended for those parties that aren't vendors in the traditional sense of being a Home Depot or CVS that's regularly engaged in the business of selling stuff. And it's meant to protect just the type of situation you mentioned, and a one-time or two-time a year event, so that vendor doesn't, that nonprofit organization doesn't have to go register with the state as a vendor and get set up for the whole. It's a bit of a burdensome process to get registered with the state and then begin to collect and remit sales taxes, even for one state alone, not a process you really want to get into. And again, these rules are going to vary immensely by states. Maryland's got an exemption, I think, caps out at $10,000, for example, is you can engage in sort of an isolated sale provided it doesn't get above $10,000. And so that, if you had just a one-day auction event, you might well fit within that as a way to avoid it. A slight parallel that's really more targeted at the tourist industry and convention industry is a number of states will have for a vendor that's not present in the state on an ongoing basis, a number of days-based exemption is if you are in the state for only a limited number of days, 7 days or 14 days, the state will not obligate you to register as a vendor and begin collecting sales tax. And that's, in my mind, that really just helps protect the convention situation from having to come in and take on a whole process because you've come to use their convention facility once every 5 years. You don't have to register and begin collecting sales tax. So this is a part I guess I'm obligated to talk about, but none of you really want to hear about, which is what if you haven't been doing these things and you should have been doing them?
What makes you think none of them want to hear about that?
So we go back to some fundamentals in sales and use tax is that you've got the idea that both parties to the transaction generally are obligated to see that the tax gets paid. It's generally the buyer that's responsible for paying the tax and the seller being responsible for collecting and remitting that tax. just as I said, that's not something you'll find in every state that's phrased that way, but that's the general theme. But at the end of the day, the theme is pretty uniform that both parties are going to be liable. Again, the seller being liable only if it has that degree of connection with the state that permits the state to be able to obligate it to collect the tax. The surprise I've found a number of times over the years is with officers, in that sales tax is different than income tax, in that with income tax, you may have earned $100 and the state is asking you to take from your pocket, from your $100, please pay me, the district government, $6 of that money. But it's your money that's being handed over. With sales tax, the state's perspective is it's always the state's money. That you've made a sale transaction for $10, but the $6 DC sales tax was never your money to begin with. It's the District of Columbia's money that you're acting in sort of a trustee role to collect and remit. And so there's sort of a higher level of liability tagged to sales tax. And it's similar to what you see on the withholding side, where withholding on the income tax side is not your money you're collecting if you're a business nonprofit that's got to pay withholding taxes on behalf of your employees. And where that leads to is officers having liability for unpaid sales tax of the venture. And for good ongoing ventures, this doesn't come up too often. Where it does come up fairly often is with ventures that fail. And when the choice comes down, do we pay our staff or do we pay the D.C. government our sales tax? It's often, well, we're hoping to live another day, so we'll pay our staff to come in for another day, and we'll deal with D.C. another day down the road. And someday that catches up with them, and the organization has sort of begun to fall apart. And D.C. realizes the organization doesn't have any money, and it looks to who the officers are in terms of who's registered, who's on the tax returns, and they can pursue those officers personally for the unpaid D.C. sales tax. In the state of Maryland, I've encountered this with people getting very surprised because they'll have one of their buddies who they've signed on to the liquor license process for. And to sign on, just to get a liquor license, you have to have your officers sign on. And somebody will have their buddy sign on as one of the officers, not realizing that they're also selling on to the sales tax liability of the company, which someday goes defunct, and they suddenly realize they're an officer that they didn't think they were. One other subset here to be aware of is the sort of statute of limitations topic. For most taxes, if some period of time goes by, the state can no longer go after you. It's typically 3 or 4 years. So if you haven't been complying or realize after the fact you should have been complying and don't comply, if enough time goes by, you can kind of breathe a sigh of relief and realize enough time has passed that the state can no longer come after you for taxes 5 years ago. But with most taxes, sales tax included, that period only starts to run if you have in fact filed tax returns. So that if tax returns have never been filed, there's no limitations period on how far back a state can go. And that's been a big topic in these interstate sales transactions, which underlie the whole Wayfair topic, in that if California says you as a DC vendor should have been collecting California sales tax for the past 15 years, and gee, you didn't even know you were supposed to be, and let alone you never filed a tax return with California, California is going to view that as an open-ended period of liability. So at the end of the day, it's sort of a practical balancing of these risks when you get into the Wayfair type discussion of we are an exempt organization, we are selling goods and services, our exemption certificate doesn't in any way protect us from the obligation to collect sales tax when we sell to other parties. If we're selling to parties in D.C., we clearly have obligation to collect. But it then goes to this question of if we're selling to folks outside of D.C., our members, our affiliates, through our affiliates, do we have an obligation in other states to collect tax? That's where the real business judgments come into play. We've technically got these nice rules of 200 sales transactions or $100,000. And again, those standards are going to vary by the states, but that's a sort of common theme. And you've got to sort of balance the different exposures involved of open-ended liabilities, officer liability against the costs of compliance. And that really is a major factor. It's just the cost of going into other states, registering on an ongoing basis, collecting sales tax, that few ever really want to cross that threshold of registering to do business or registering to collect tax. Is there anything else on the sales tax?
Yeah, I had a couple more webinar questions on the sales tax. One is a lot of charities give premiums. You make a donation, you get a coffee mug back or whatever it is. And you know in advance that if you make that donation, you're going to get the coffee mug or the tote bag or whatever it is. Why is that not? And nobody's paying sales tax on that, but why aren't they? We're hoping you have a good reason.
Don't know if I do necessarily have a good reason. I think most times organizations are going to try to fit that in their sort of casual or isolated sales exemption is
even if they're
probably
getting
the basis.
Hundreds of thousands of donations. But yeah, I like the way you think. Yeah. So maybe it's just industry standard and we're all just bound. We're bonded together. We're all going to have the consistent practice of doing that. Did you have? No. Okay. The last question I'll ask.
I'll comment a little more on that. I mean, there is the idea of trying to just distinguish the gift from the donation back as being separate things, but it's a different commentary on that is there are many examples you will find throughout our society of that where states sort of look the other way.
Right, and it's just a token. You're getting much more than it doesn't look like a sale because you're getting much more. You're giving much more than what the mug is worth, and you have to by IRS rules. So it's perhaps the idea that it is not really a sale; it really is an acknowledgement. Well,
but as I have encountered your question frequently because you get all types of fundraisers that take that mode, be it from Boy Scouts selling popcorn, Girl Scouts selling cookies, pizza sales, all those things that one has to question why isn't sales tax being applied? And for the most part, the best answer I've ever came up with is states sort of look the other way.
Okay, that works. And then the last question on this was a question about, can you talk a little bit about differences between C3s and C6s in the sales tax world? Now, we know that C3s are generally going to be the only ones that can qualify for an exemption on what they buy. Otherwise, I think pretty much everything you've said would apply to C3s and C6s similarly. Is that right?
Very much so. I mean, in some places, you are going to find that C6s may be able to get sales tax exemption based on their exempt status. Beyond that, I think everything in our discussion pretty much applies across the board to C6s just as another category of exempt organization along with C4s and whatever.
Okay. Any other questions in the room before we move on to property tax? Okay, go.
So just a short discussion of property tax, which is pretty much going to be sort of a parallel universe to sales tax. Again, beginning with the presumption that everything is taxable, but that as an exempt organization, to the extent you own real property or tangible personal property, you're going to need to file an exemption application. Let me go back to one point on sales tax before I leave it, because I didn't. It's on the use tax piece, and it kind of comes to mind here as we talk about personal property tax. With use tax, we commented about how there may not be much compliance among us as individuals, but for virtually any audit of a business, the low-hanging fruit in the sales tax world for the state auditor is use tax, in that for any business that has ordered from Dell their computers and Dell didn't collect sales tax from them, their local jurisdiction is expecting them to collect to pay use tax. And as a business, they say that's the low-hanging fruit for the state sales tax auditor. They will come in and they'll look at your income tax, your exempt organization tax return and see what property has popped onto it during the past year. They'll look at your personal property tax filings with the state and see what property has shown up during the past year and say, please show us the receipts for when you bought that property And we'd like to see on the receipts where the sales tax got paid when you bought it. And if you can't provide those receipts, it's a very easy slam dunk. Well, you need to pay us DC 6% use tax on the computers you ordered from Dell in Texas, from their Texas office or something. So, and that just sort of my segues over to personal property, and that there are two universes of property. One is your real property, bricks and mortar buildings, and then there's sort
That
of
you own, not lease.
that you own, yep. And then there's the tangible personal property, which in most jurisdictions is also subject to tax, your chairs, tables, and computers. And so each of those is going to have an exemption process to claim exemption, and in general it's going to be much similar to the sales and use tax world. This is it's interesting to see these charts sometimes. This is just where sort of the property tax burden is, and you can kind of come away with a theme from this that the states where you've got the real property tax as a significant component is sort of the skewed toward the east and northeast of the United States, are the states that really are heavy tax burdens. If we went back to the chart that's probably in your materials, let's see. Yeah, if you have to go back to the chart at page, it's early on, it's the bluish one. You can sort of see how sales and use tax has a totally different skewing. It tends to be more of a southern and southwestern skewing is where the taxes there are really heavy, but that's just kind of a side commentary on things. So the common topic I get hit with is this mix of things which comes alive as requirements in the property tax world, is that there are typically two prongs of requirement that, assuming you're otherwise eligible for property tax exemption, which again is going to tend to favor 501c3 organizations, is a requirement that you both use the property in your exempt purposes and that you own the property. And I'll get this in different contexts. I'll get it in the context where, gee, we are using that property clearly in fulfillment of our exempt purpose, no question. Oh, but it got transferred to one of your affiliate entities, which doesn't happen to have in its own name exempt status. So you've met the use prong for property tax exemption, but not the ownership prong. And I'll get it the other way. We own the property. Why is there any question about our entitlement to the exemption? Well, you've got a lease on the property to that other 501c3 organization that's a good friend of yours. And in many states, they're going to treat leased property where you've got some extra office space in your building that you lease out as not being used in fulfillment of your exempt purposes, and be trying to subject part of your facilities to tax based on the failure to have it used in fulfillment of your exempt purposes. And there's layers of arguments you get into. Well, it's being used by another exempt organization in fulfillment of their exempt purposes. And in some jurisdictions, they'll then say, well, but are you leasing to them at commercial rates? That's bad because it's just like being another landlord. Or are you, in fact, giving them a discount that is reflective of some charitable purpose on your own part? So that's the type analysis one gets into on, if you are eligible, how you have to be certain to maintain both ownership and use of the property to have ongoing exemption for your property. Over the past, 5 or 10 years, there's been a trend in the property tax world of greater challenges to the eligibility of property for exemption by exempt organizations. And you'll typically see this happening in cities which are getting more physically challenged by distressed economic times. And they're often cities that have a major taxpayer base that's exempt. They'll often have big healthcare organizations or educational organizations that have a lot of property that's exempt, in addition to their own governmental property being exempt. And they will, and in a few cases I've cited here, challenge the exemption on the basis that the property is no longer being used in fulfillment of the exempt purposes. And these are often in the healthcare area. That's probably the most common area I've seen them in, because healthcare organizations tend to have lots of facilities and they tend to do lots of different things. And in some of those lots of facilities, they may do some of their things which are pretty fringe in terms of being within their exempt purposes. So the state may be able to focus on particular facilities and challenge the exemption, and that the exemption you sort of apply as an entity, but the exemption really relates to particular property. Each property gets evaluated separately as to whether it's exempt. And for example, I dealt with a Maryland or Virginia healthcare organization that had different clinics, and the taxing authority focused on the fact that, gee, there are clinics in urban centers that are nice and clearly getting lots of indigent usage, and therefore clearly having charitable usage, but those clinics in McLean or Bethesda, do you really get indigent patients walking in off the streets? Those look like pretty high-level clinics, and questioned whether in specific sites charitable care was still going on that merited exemption for those unique sites. So that's been a sort of trend seen over time that's been growing, is challenges to, in particular, charitable status, and in particular in the healthcare industry. And the charitable status has been the one that's, I think, been most easily challengeable, because a lot of organizations do have aspects of their activities that's sort of hard to justify as charitable when you view them in isolation from the overall mission of the organization, which is part of the challenge with the state taxing authority. Is you go in and say, our overall mission is doing this. Each and every one of our facilities serves to fulfill that mission, but then the taxing authority will isolate and look at a specific facility and question, well, do you really fulfill your mission in that facility? In D.C. in particular, I really haven't seen a lot of challenge in this area, but others may have more experience as to whether they've seen or encountered this, but it is a trend across the country. One slightly lesser trend is, as opposed to direct challenges, there have been cases, in the one I mentioned here in New Jersey, that did go through a litigation process, but the ultimate result was sort of a voluntary agreement between the university system there and the local city to have the exempt organization make voluntary payments to the city, acknowledging that they were getting major benefits from the city that they weren't fully supporting by the tax base that they were claiming exemption from. And this is something I've encountered more frequently in recent years. I wanted to hit on as kind of a last point in the world of taxation, because a lot of organizations seem to be headed this path, and it can result in confusion in that a number of years back, 20-some years back, the limited liability company popped on the scene. And it took a number of years to sort out just what that creature was. It's a creature under state law that you can create just like a corporation, but the income tax side of it took a while to sort out. And eventually we ended up with this magic under federal income tax law that has gotten a lot of focus, which is that your nonprofit corporation is a respected entity under state law. It has obtained exempt status from the IRS, but it may, when it buys property or goes off to engage in a particular activity, have its corporate attorneys or its real estate attorneys say, we think it would be a good idea if you isolated that new property you bought or that new activity you're going to go off and do into a limited liability company. And we can set that up, and you can be the sole member of that limited liability company. And, you know, it'll give you some protection maybe from liability and contract. It may help you when you buy the property or when you want to sell the property, make that happen more easily. So there are good things to do it this way. And by the way, there's no real income tax hassle on this, because the magic of federal income tax law says that entity is disregarded. Poof, it just disappears. It doesn't count as if it existed for income tax purposes. So you've got this weird dichotomy of an entity that really exists under state law, that state government views as a true legal entity just like a corporation, But you don't have to, for income tax purposes, go through any process of getting separate exempt status because it doesn't exist for income tax purposes. It poof disappears, is disregarded. Well, that fine disregard status doesn't necessarily carry over to other taxes, in that what comes out of the income tax world generally doesn't carry over into the sales tax or property tax world. So that if you've wonderfully segregated some activity or property into a separate LLC, that for your income tax purposes is treated just as though it's owned by your parent exempt organization, you may well find that when that activity involves buying something in the name of your wholly owned limited liability company, and you try to hand over your exemption number, they're going to say this exemption number doesn't match with your exempt organization LLC number one. Your exemption number matches with parent corporation exemption, but it's a different entity for sales tax purposes. You need to get your own exemption for that separate entity. And you then head down a really weird path of, gee, if you want to get a federal exemption for your disregarded LLC entity, well, it doesn't exist for federal income tax purposes. So how do you go to your state to get an exemption for it when you haven't gotten a federal exemption? So there aren't necessarily good, easy answers to that. It can take unique situations requiring each their own answer. And the same topic can come up with property tax. If you isolate a property in a separate entity, you may get the question of whether the exempt status of your parent carries over to exempt the property of that separate wholly owned limited liability company. Now, if you look like something like D.C., many states will have addressed this, at least on the property tax side, by having some form of exemption for title holding companies, that if you've got a subsidiary entity that the only thing it does is hold title to property for you, you may get exemption based on the parent status. But I throw this more out just as an awareness rather than a topic on which I have answers. It's one I more and more frequently encounter as a challenge as to how to deal with the after-the-fact consequences at the state level of wonderful things that were done by the federal tax advisors. So that's where I wrap up.
All right. Any last questions on sales or property tax before we turn over to Liz to talk about opportunity zones for a whole new, fresh look on brand new stuff? Not that Wayfair isn't brand new. Okay, Liz.
Thanks. So I'm just going to talk briefly about the Opportunity Zone program. And this is a program that was enacted as part of the 2017 Tax Act. Since we don't have a ton of time, we're going to go through it briefly. But if you are more interested in it, I will just plug our other upcoming webinar, which is later this month, which is focused just on Opportunity Zone funds. So what is the Opportunity Zone program? It's basically a tax incentive that is designed to attract investors to low-income communities. And it gives investors a lot of different tax benefits depending on how long they hold their investment in this qualified Opportunity Zone fund. So the immediate benefit for investors is deferral of gain. What does that mean? Let's say you bought a share of stock for $50 and you sell it this year for $150. You have $100 of gain. And normally you would pay tax on this gain. So if we assume a 20% tax rate, you pay $20 of tax, you got $150, you end up with $130 in your pocket. Well, under this program, the IRS says, you don't have to pay us our $20 right now. You're going to have to pay us eventually, but right now you can keep your $20 as long as you roll over your $100 of gain into what is called a qualified opportunity fund. So the key part is you have to roll over the gain. In our example, $100. You don't have to roll over the whole, the $20 that you save in the tax. And you get to defer your tax on this gain until the later of the day you sell your investment in the fund or 2026. So that's why you've seen it wasn't really discussed too much after the new Tax Act. There were a lot more provisions that got a lot of attention, but it's become really big within the last few months as people start to do their year-end planning. Because obviously the earlier you sell your investment and put it into this fund, the longer deferral you get, so people like that. So that's the first benefit. You get this immediate deferral. The second benefit is that if you hold your investment in the fund for 5 years or 7 years, you also get to exclude some of your gain from your original investment. So our original investment was that stock that we had, and we had $100 of gain. So let's say you hold your investment in the new investment, which is the fund, for 7 years, Instead of paying tax on $100, you only have to pay tax on $85. So that's great. You've now saved 15% of your tax. If you hold it only for 5 years, you get to shield 10% of your gain. The biggest benefit, and the one that people are most focused on, is that if you roll over your gain into one of these qualified opportunity funds, to the extent of all of the new appreciation attributable to this new investment, all of that is free from tax if you hold it for a certain period of time. So let's say you took your $100 of gain and you put it into one of these funds and it increased to $200. So when you go to sell it, you don't have to pay any tax on that extra $100 of gain. So this is a huge benefit, and it's designed to attract investors into these low-income communities. So what is a fund? An Opportunity Zone fund is an investment vehicle that's a corporation or a partnership that invests in qualified Opportunity Zone property, and at least 90% of the fund's assets are zone property. And zone property includes equity interests in another entity that operates a qualified Opportunity Zone business or qualified Opportunity Zone business property itself. Where are opportunity zones located? So after the passage of the 2017 Tax Act, there was an opportunity for governors to nominate various census tracts in their states to be designated as an opportunity zone. So that process is over. So if you go, if you look online, you can find out if you are in a census tract or if your business is in a census tract that has been designated as an opportunity zone. And the designations were based on the income of the people who reside in the community. So there has been some discussion because not a lot of the qualified opportunity zones, but certainly some of them are in locations that you would not think of as being low-income communities. So these can be really commercial areas, areas that are near airports, places where there aren't a lot of people who live there, and the people who do live there have a lower income. But there are obviously a lot of opportunity zones in what we traditionally would think of as a distressed or a low-income community. So since this is specifically for nonprofits, we want to talk a little bit about what the role of a nonprofit would be in terms of this program. And to be perfectly honest, since it's new and the tax year hasn't even ended yet, it's pretty unclear. The most similar program is the New Markets Tax Credit. And there, after a series of years, a structure became very clear, and there's a clear relationship between nonprofits and banks and investors and how that functions. But this program is a little bit different than the New Markets Tax Credit. First of all, the investing entity, the fund, self-certifies. So in the New Markets Tax Credit side, you may know the investor entity has to get certified by another party. Here, we don't have that situation. More importantly, in the New Markets Tax Credit side, the IRS has said that if you are running a program in a New Markets Tax Credit vicinity, you are deemed to be engaged in a trade or business. To qualify for the Opportunity Zone program, you also need to be in a trade or business, but there's no rule that says a nonprofit is engaged in a trade or business for this purpose. So at the moment, you can't really have a nonprofit that's just going to run its own Opportunity Zone fund. So that being said, there are some things that you can think about doing now. The two biggest ones that have been discussed are nonprofits setting up for-profit subsidiaries that would run a trade or business in a low-income community, or partnering with another entity and engaging in a joint venture. And I think there's benefits both for the nonprofit and for the investor. So on the nonprofit side, obviously it can be difficult to attract capital into low-income communities. This is a great way to advertise and get some capital in there because the investors get such a huge tax benefit. On the other side, investors are seeing this, obviously when you start an investment, you're very optimistic. And to the extent that this investment makes money, this is a great program. To the extent that it doesn't make money, it may not be that great of a program. So where nonprofits can really come in is you guys have experience in a lot of these communities. You can really act as a liaison to help the investors, help the capital sort of understand what the needs are and how to make their investment the best that it can be so that they can actually make some money and enjoy these tax benefits that they're trying to achieve. So this just kind of goes, this next slide just sort of talks about the same thing. You can use the Opportunity Zone program to attract funding for a corollary profit-oriented activity that maybe you run through a for-profit subsidiary or through a joint venture. One of the suggestions was if you have something like an affordable housing community that you're developing to kind of attract other businesses there that would be for-profit. And the other one is obviously just having a joint venture. The one other thing that I will note here is that if you are familiar with the New Markets Tax Credit, there is an opportunity for nonprofits to structure investments such that you are you qualify for the New Markets Tax Credit and for the Qualified Opportunity Zone program. So that's something to think about. Qualified Opportunity Zone funds can invest in residential rental housing, but it has to be new property or existing property that's purchased after 2017. So it can't be for something that you had prior to 2017 that you're currently in the process of developing.
Yeah, there is a webinar question, which I haven't had a chance to read, so we'll read it in real time. Can an opportunity fund be invested in an opportunity zone in a commercial timberland project that will be managed for income? In other words, can the substantial improvement requirement be met in a project that seeks to manage a forest?
So this question kind of goes more into the technical details that we left out when we're talking about so as we know, we set up a fund and the fund can invest in a qualified opportunity zone business, and the business has to have a certain portion of its property being used in the opportunity zone. And there's also this corollary that there has to be substantial improvement to either using those in the zone, or there has to be substantial improvement to the property. I will defer to Walter on whether or not a timberland would be substantially improved.
I have the answer, yes. This is the answer you should have given. Tune in next week for our other webinar, where we'll have a panel of about 6 of us, and perhaps we can provide greater focus to that type question, because really that is a very detailed question. I don't know if there is an answer. I certainly don't have an answer to it, but I would say that's more of the type question for our in-depth seminar.
Okay, so this is a taste, and that will be a 3-course meal.
I did have sort of an overview perspective, perhaps, and Liz, you can comment on my takeaways, which is that it's a reach now to find how nonprofits are going to fit into the Opportunity Zone program, in the sense that it's just a humongous mega driver of capital into low-income communities, which is where a lot of nonprofits are. But the fundamental thing you said to me that I heard was the trader business aspect, that it's got to be a trader business that's using the money, and nonprofits by definition aren't in a trader business. And the New Market program worked just because it had an exception. And so you've got to find some exceptional route to make it work.
Right, and that's why I think the focus so far has been on creating a for-profit subsidiary so that you can have something that is engaged in a trader business. Like you said, in the New Markets Tax Credit world, there is this special provision that says a nonprofit is deemed to be in a trader business if you're engaging in that kind of activity, but there hasn't really been any discussion in adding a corollary provision on the Opportunity Zone side. So I think it's going to be, the structure of these transactions are going to be a lot different.
And I don't know if you've got any thoughts on where the rental topic goes. I mean, your investor comes in and builds specifically for the nonprofit, but then rents to the nonprofit. And I thought there was a whole line of concern of whether rental is a trader business in and of itself. And so I sort of thought that was still a hanging question out there also, whether the nonprofit could kind of artificially get in by a lease mode. But again, I don't know that that one's been answered yet either.
No, I think that's still open. So that's the other thing, is that this is, since it's new, it's definitely developing. We got guidance from the IRS in October. They said more guidance is coming, including guidance on the guidance that they already issued. So definitely something to keep your eye on as it develops.
Great. Any other questions about this? Well, if not, we have one more webinar question, which brings us into really a very, very hot sales and local tax topic, which I will ask Walter to comment on. And that will be it. And that is the whole, so the last year's Tax Act put a cap on how much you could deduct for your state and local taxes as an individual. And that was widely viewed as an attack on the blue states where property taxes tend to be higher. So some of those blue states have fought back by enacting laws saying that you can make a charitable contribution and then the state will give you a credit toward paying, credit that toward your property taxes. And that allows you to pay a lot of money and still keep the total of your property tax under something you can deduct. And then you deduct the rest as a charitable contribution, basically. And the IRS has come out and said that's not going to work, folks. And the question is the IRS going to be able to make that stick, and what's going to happen next? Because we're all about prognostication here.
Yeah, and Liz, you should chime in on your thoughts too. I mean, my sense is that in the long run, the IRS is going to win on that battle. That some of the states are going to take it into the court system, but at the end of the day, it's likely that federal law will reign supreme under the state's efforts to undermine it in the way they've done with this fairly artificial construct of you donate to the state and get a donation deduction that you can still fully deduct in lieu of your otherwise tax deductions workaround. A number of the states have some more creative workarounds that may well work because they don't try to do that, but they're much more complicated and they don't have the benefit. They're really payroll-based type workarounds. And some of those I don't see how the IRS is going to be able to challenge, but they are much more limited use. And the dollar volume that can be channeled through them, I think, is much lower. So I don't think the IRS will have as much concern with those. But Liz, you any other comment?
Yeah, I agree. I think the one that we've really looked at is New York, and there the benefit is, I think for this year, 1.5% of your payroll taxes. So given the cost of having to set it up and implement
That's
it.
a totally alternative approach.
Right. There may not be as much of a benefit there, and that's one that potentially could work, but the economics have to work, and it's not clear whether it actually will.
All right. Any other questions? All right. Thank you very much. Please join me in thanking our speakers.